Today we will learn and reflect on the recent Supreme Court Dobbs case overturning the Roe v. Wade decision on abortion. Sometimes I get the impression that many of those who see themselves as devout Christians believe that if you choose to judge those single women who contemplate abortion, then that judgment is virtue. But if you choose to show compassion for anyone considering this horrible decision, then that compassion is somehow contrary to Christian values. Now, why do I say this? Because many of my Christian friends only want to see the short memes. If they come across a serious and longish article that even suggests that we should feel compassion towards any poor mother considering abortion for any reason, many want to jump to a knee-jerk conclusion that the author must somehow be saying that it's okay to kill babies. We need to change the narrative. To say that you're pro-life implies that your opponent is pro-death. How judgmental is that? But to say that you're pro-choice implies that you only want to live life by the rules you manufacture yourself, that there's no objective standard of truth and virtue that you should strive for. What we need are more people in the world who truly love their neighbor as themselves, who are pro-compassion. At the end of our talk, we'll discuss the sources used for this video. Please feel free to follow along in the PowerPoint scripts we uploaded to SlideShare. Please, we welcome interesting questions in the comments. Let us learn and reflect together. There are some really heartbreaking situations involving abortion. Should abortion be allowed if the mother's or the baby's life is in danger? Should abortion be allowed in case of rape or incest? Should abortion be permitted if it's likely the mother would otherwise commit suicide? Should abortions be permitted to reduce the number of deaths caused by botched abortions by coat hangers or Lysol? You show no respect when you judgmentally shout at someone who's forced to make a really difficult life decision, whether it's a difficult pregnancy, a divorce, whether to place parents with dementia in nursing homes. People in those difficult situations don't need their shouts. They need you to listen and show some compassion. Compassion is what shows the world that we are truly Christian. Demonizing ladies who are pondering pregnancies, particularly ladies with problem pregnancies, where their life and or the life of their unborn child is in danger, does not help. Jesus was compassionate towards sinners, so should we always be compassionate with our neighbors, even if we question our neighbors' moral decisions. Because we are all sinners. There's an important right that's been ignored by all sides. And that is a critical right that should be protected, that everyone is overlooked. The right of our qualified medical doctors to make professional medical decisions for the benefit of their patients with no political interference. If doctors and hospitals are forced to worry about whether they will be sued, they will be hindered in providing proper care, and more of their patients will die. Many of these draconian laws that are being passed now don't provide an exception for abortions when the life of the mother and the infant is endangered. But even when there is a humane exception, this fact remains. While there are clear-cut cases where the mother's or infant's life is definitely endangered if the pregnancy is carried to term, quite often whether life is endangered is a matter of professional judgment. We need to protect the rights of doctors to make the professional judgments without fear of lawsuits. That is why they attend medical school for so many years. And you might say, well, what if the doctors are liberal? My response to that is that's a matter between that liberal doctor and Jesus. We don't need to get involved in judgmental affairs. Our prior reflection on Roe v. Wade included reflections on the Catholic Catechism teachings on abortion, history of abortion, and the moral dilemmas posed by abortion, the history of the Roe v. Wade decision, and reflections on the actual opinion itself that we read, and reflections on which moral values should be enforced by the state. For example, murder. Yes, the state should prohibit murder. Prohibition, drinking of alcohol, well, maybe not so much. I previously expressed my personal beliefs based on careful reflection. I agree 100% with the Catholic teachings on abortion in the Catholic Catechism, and these teachings were quoted and discussed in the prior video. The opposite of pro-life is pro-death, not pro-choice. I'm uncomfortable with a radical, in all cases, pro-choice position, but as a Christian, I am always pro-compassion. Compassionate towards the unborn, the born, the mother, the doctors, the poor, the sick, the family, and towards low-income workers. Pro-life concerns do not end at birth. Pro-life concerns are from cradle to grave, not just from conception to birth. And Pope Francis seconds me on that belief. Our Christian twofold love of God and neighbor means we must be compassionate towards those who face difficult decisions in their lives, even if we feel that they are considering immoral actions. And abortion, like it or not, is always a personal moral decision. If the government permits mothers with their doctors to make this decision when the mother's or infant's life is in danger, this does not mean that the government seeks to kill babies. Now, abortion is a complex issue. These are my further reflections in my prior video. I'm not going to read them here. My prior video has the context for these reflections. To summarize, we reflected on the scenarios where abortion is considered. We reflected on how abortion affects differently the wealthy, the middle class, and the poor women of our society. And we reflected on ways where we can be more compassionate about the issue of abortion, how we can respectfully encourage healthy morals and issues surrounding abortion. What has changed since Roe v. Wade in 1868, and why 1868? Well, we'll soon see. Justice Alito delivered the majority opinion. 3 justices wrote concurring opinions, and Justices Breyer, Sotomayor, and Kagan filed a dissenting opinion. Just as we read the actual Roe v. Wade opinion in our prior video, so for this video we also read the Dobbs v. Jackson Women's Health Organization opinion that overturned Roe v. Wade. And the majority opinion written by Alito of Dobbs says this: the court finds that the right to abortion is not deeply rooted in the nation's history and tradition. However, the dissenting justices point out that the early state laws in the U.S. do provide support for abortions before the fetus quickens or moves in the womb. Since Roe and the KC opinion upholding Roe were founded on the 14th Amendment guaranteeing due process, the majority makes a big show of showing how the majority of states outlawed abortion in 1868. And that begs the question, what does this prove? Mainly, this proves that abortion and any other medical operation was exceedingly risky in 1868. Don't you remember the Civil War movies where patients swilled bottles of whiskey before the doctors got out the saw to do their operations? Well, at the time, medicine was primitive. Doctors were experimenting with chloroform and anesthesia at the time. The techniques would not be perfected until later in the century. Given the primitive state of medical science at the time, the fact that most states outlawed abortion in 1868 should not surprise anyone. Justice Alito accurately summarizes the opposing positions on abortion. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. Some believe fervently that a human person comes into being at conception and that abortion ends an innocent life. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still others in a third group think that abortion should be allowed under some but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. Likewise, Alito accurately stated that Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin, under which states were forbidden to adopt any regulation that imposed an undue burden on a woman's right to have an abortion. And the decision provided no clear guidance about the difference between a due and an undue burden, which is a puzzling criticism because many Supreme Court decisions have such vague guidance. And we can see such vague guidance in Brown versus Board of Education, where the Supreme Court ruled that segregation should proceed with all due deliberate speed. Now, what the heck is deliberate speed? Anyway, Justice Alito also casually dismisses the historical summary of abortion in the written opinion of Roe v. Wade as irrelevant, but he's missing the point. Justice Blackmun, who wrote the original Roe v. Wade opinion, included much history of abortion that was admittedly legally irrelevant. But he was also respectful of the deeply held opinions of the faithful, so he felt compelled to also review the opinions of the Church Fathers and the ancient philosophers. Blackmun spent many more months and far more thought in drafting Roe v. Wade than Alito did in drafting his Dobbs majority opinion. Justice Alito spends much of the opinion comparing Dobbs, which overruled Roe v. Wade, to the Brown v. Board of Education opinion. Brown mandated school desegregation using all deliberate speed, overturning the Plessy versus Ferguson doctrine of separate but equal, which sanctioned the Jim Crow segregation system that held blacks in a subservient position until the Civil Rights era. He argues that Dobbs overruling Roe is following in the footsteps of how Brown overruled Plessy. We found this comparison between Dobbs and Brown to be bizarre, and we agree with the article in the Atlantic magazine that argues persuasively that the logic of the Dobbs opinion is closer to Plessy than it is to Brown. So we're not going to repeat the arguments here. You can read it for yourself. What does originalism mean? Justice Alito summarizes, "We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey abrogated that authority." This is the key sentence. "We now overrule those decisions and return that authority to the people and their elected representatives." Thus, Roe v. Wade has been overturned. In his opinion, Alito appears to provide lip service to the 14th Amendment and the originalism judicial doctrine that the conservative justices ascribe to does state that the original intent of those who drafted the amendment should prevail. But he misses the point of the 14th Amendment entirely. And the point of the 14th Amendment is simple. The people and their elected representatives do not have the final authority to deny due process to their citizens. This is the wording of the Due Process Clause of the 14th Amendment. "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law," due process, "nor deny to any person within its jurisdiction the equal protection of the laws." Now, we can clearly comprehend why the 14th Amendment was necessary when we reflect on the recalcitrance of the southern states during and after the Civil War in this review of American history. And the Civil War begins when the southern states secede, contesting the election of Abraham Lincoln as president, fearing the abolition of slavery. Does that ring a bell? Abraham Lincoln issues the Emancipation Proclamation, and the 13th Amendment abolishes slavery. After the Civil War, under lenient presidential Reconstruction, the southern states enact harsh black codes re-enslaving the newly freed blacks, and many Confederate officials are elected to Congress. There is a backlash by northern voters. The radical Republicans gain a congressional supermajority, and they refuse to seat the Confederate officials elected to Congress. Under radical Reconstruction, federal troops are sent into the southern states, and the South is compelled, at gunpoint, to grant blacks civil rights, due process, and the right to vote. The electorate of the southern states was definitely, solidly against this. The 14th Amendment guarantees due process, and the 15th Amendment guarantees that all residents are citizens and that blacks are able to vote. And Confederate states can be readmitted to the Union only after they ratify all three Reconstruction Amendments. And if they don't want to do that, they don't get to be readmitted. The federal troops will stay forever. In the disputed 1876 presidential election, the southern states again threatened civil war. The North relents. In exchange for recognition of the election of a Republican president, federal troops are withdrawn from the South, ending Reconstruction. And what happened after that? Well, the South enacted the brutal Jim Crow segregation laws, denying blacks due process and the right to vote. Thousands of blacks are lynched, and the KKK Night Riders terrorize blacks with impunity. And Jim Crow, in effect, re-enslaves the freed slaves. And the Reconstruction Amendments are neutered by the Supreme Court justices. Doesn't that sound familiar? But the pressure for civil rights continue. In the Supreme Court Brown decision and the Civil Rights Acts of 1965 breathe life back into the Reconstruction Amendments, re-establishing their original intent. American history clearly demonstrates that the Reconstruction Amendments empower the federal government to ensure due process for U.S. citizens and can overrule the decisions of state government and electorates who try to deny this due process. Due process is determined at the federal level, not at the state level. The federal government can set a minimum standard of how citizens should be treated, overriding the wishes of state governments and state electorates. This is indeed why Eric Foner, in his History of the Reconstruction Amendments, calls this a second founding of the United States, and that is indeed a very apt title. Now, Justice Thomas, in his concurring opinion, thoroughly scared the dissenting justices. Justice Thomas declares, "Thus, I agree that nothing in the court's opinion should be understood to cast doubts on precedents that do not concern abortion. For that reason, in future cases, we should reconsider all the court's substantive due process precedents, including Griswold, Lawrence, and Obergefell. Now, the 1965 Griswold case ruled that married couples could purchase contraceptives without government restriction. The 2003 Lawrence case ruled that states should not criminalize sodomy. And the 2015 Obergefell case ruled that states could not prevent same-sex couples from getting married. And then Justice Thomas declares, after overruling these demonstrably erroneous decisions, the question would remain whether other constitutional provisions guaranteeing the myriad rights that our substantive due process cases have generated. And the dissenting justices note, so at least one justice is planning to use the ticket of today's decision again and again and again. Which begs the question, how can the Supreme Court enforce due process if it declines to define what due process is? Justice Thomas desires to do nothing less than totally neuter the due process clause of the 14th Amendment. Chief Justice Roberts, in his concurring opinion, states that the court's decision to overrule Roe and Casey is a serious jolt to the legal system, regardless of how you view these cases. We concur with this concern, although not with his concurrence. Two of the three dissenting justices are women. They dissent. For half a century, Roe v. Wade and Casey have protected the liberty and equality of women. Roe held and Casey reaffirmed that the Constitution safeguards a woman's right to decide for herself whether to bear a child. Roe held and Casey reaffirmed that in the first stages of pregnancy, the government should not make that decision for women. The government cannot control a woman's body or the course of a woman's life. It could not determine what the woman's future would be. Respecting a woman as an autonomous being and granting her full equality meant giving her substantial choice over this most personal and most consequential of all life decisions. The dissenting justices list how many states seek to deny abortion. They seek to deny the use of abortion pills. They seek to deny abortion in cases of rape or incest. They seek to deny abortion when the fetus has severe medical conditions. And some states want to deny abortion when the mother's life is endangered. And the dissenting justices fear that states can imprison abortion providers. States can criminalize abortions, throwing young women in jail. More states like Texas will encourage vigilante justice to enforce abortions where neighbor sues neighbor, in essence permitting harassment lawsuits. They fear that states will forbid their citizens to travel out of state to obtain abortions. What about miscarriages? The dissenting justices note that most medical treatments for miscarriage are identical to those used in abortions. Blanket restrictions on, quote, abortion, unquote, procedures and medications therefore may be understood to deprive women of effective treatment for miscarriages, which occur in 10 to 30% of pregnancies. The dissenting justices warn that the majority's ruling today invites a host of questions about interstate conflicts. Can a state bar women from traveling to another state to obtain an abortion? Can a state prohibit advertising of out-of-state abortions or helping women to travel to out-of-state providers? Can a state interfere with the mailing of drugs used for medical abortions? And the dissenting justices observe, the Constitution protects travel and speech and interstate commerce. So today's ruling will give rise to a host of new constitutional questions. Far from removing the court from the abortion issue, the majority puts the court at the center of the coming interjurisdictional abortion wars. And in footnotes, the dissenting justices note that Mississippi will greatly restrict abortion care without addressing any of the financial, health, and family needs that motivate many women to seek it. For example, in Mississippi, the state neither bans pregnancy discrimination nor requires paid parental leave. Mississippi has strict eligibility requirements for Medicaid and nutrition assistance, leaving many women and families without basic medical care or even enough food to eat. Although 86% of pregnancy-related deaths in Mississippi are due to postpartum complications, Mississippi rejected federal funding to provide a year's worth of Medicaid coverage to women after giving birth. And Mississippi has the highest infant mortality rate in the country, and some of the highest mortality rates for preterm birth, low birth weight, cesarean section, and maternal death. Most states banning abortion are the same states who bottom out in caring for their young poor mothers and their children. The dissenting justices conclude, with sorrow for this court, but more for the many millions of American women who have today lost a fundamental and constitutional protection, we dissent. Now, David Frum has an interesting essay in The Atlantic that asks an interesting question. Is Roe the new prohibition? Both abortion and prohibition attempt to legislate morals, but like all analogies, this one is imperfect, as abortion is not a universal experience like drinking alcohol. And this leads to a more interesting question. Is Dobbs the next Dred Scott case? Now, if you remember, the Dred Scott was the most detested opinion rendered by the Supreme Court that provided one of the sparks that ignited the Civil War. This infamous decision ruled that Negroes had no rights or privileges that the white man was bound to respect. In other words, they were subhuman. And the Supreme Court threatened to permit slavery in all the Western territories. President Buchanan and Chief Justice Taney, back in the day, actually thought that this opinion would bring peace to the nation, solving the slavery question once and for all. And the exact opposite occurred, of course. Do our Republican justices think that Dobbs will resolve the abortion controversy? Justice Roberts and the dissenters warn that the exact opposite will likely occur. Will the Dobbs case galvanize more women to vote Democratic in upcoming elections? We shall see. The Democrats seek to codify the principles of Roe v. Wade, and Dobbs may give the electorate the justification to support appointing 2 additional justices to bring our higher court back in balance. Will Dobbs be a factor leading to the long-term decline of the Republican Party, as happened in California decades ago when the state Republican Party became too oppressive in its cruel immigration policies? Time will tell. Now we'll discuss the sources we use for this video. Our main sources are the Dobbs and Roe opinions themselves. They're readily available on the internet. They're not difficult to read when you judiciously skip over the repetitions and the needful citings of precedents that benefit practicing lawyers. Otherwise, we recommend the sources we used for our prior video. The Great Courses has a still informative series of lectures on the Supreme Court history of Roe v. Wade, and there is an excellent book on Roe v. Wade and abortion in general. We also found 2 excellent books covering the history of abortion, one from a Christian point of view, although we did not refer to them as the Roe v. Wade opinion, has an excellent summary of the abortion history. And our prior video on abortion quotes directly from the Catholic Catechism in all the sections regarding abortion, and this is an excellent source. And we have a video on how the Catholic and Lutheran catechisms can be valuable guides on how to live a godly life. Now, in the final section of my original blog on Roe v. Wade, I sifted through some of the women's and doctors' personal stories on the internet. My purpose was not to support any pro-life or pro-choice political arguments. My purpose was to share with you stories from both sides, and I tried to weed out the polemic and manufactured stories. My purpose is not to judge anyone about the correctness of their choices. My purpose is to provoke compassion over these very difficult and heart-rending situations. In some stories, the women regretted their choices. In some stories, the women grieved their difficult choices. In some stories, the doctors tell us of the conundrums they face. And some are stories that you may not like. But there is one fact in common in all of these stories. They're all about real, live, breathing, sensitive human beings who have suffered much. People we know or encounter who suffer through similar trials need to be treated with dignity and compassion. The YouTube description includes a link to our PowerPoint script that we uploaded to SlideShare and also our blog. Please support this channel by sharing this video with your friends and by clicking on the like and subscribe buttons and by clicking on the Amazon links to purchase any of the books we discussed, which will earn us a very small affiliate commission. And please consider becoming a patron of our channel. Plus, we will host special discussion groups for our patrons. Plus, you can click on the Meetup or small M icon to participate in our online discussions, where we practice our future YouTube scripts. And please click on the links for other videos that will broaden your knowledge and improve your soul.